On September 4th of 2024, New York signed into law a law called the Retail Workers Safety Act. This act will require retail employers who have at least 10 employees to implement workplace violence prevention plans by March of 2025.
As a litigator, what weak points would you be looking for if you wanted to hold a company liable for not following this law?
So as a litigator, when you have these specific rules, you can start to look and see, did they follow the specific rules that the legislature told them to? If they were supposed to install a panic button by a certain date, did they? And you really want to hit those milestones. You don't ever want to be out of compliance with a specific rule like this because it's very hard to argue that you couldn't have done it, right?
So it almost sounds like this law makes it easier for businesses to be in compliance than if they were just under the general duty clause.
I really do think that these rules that legislatures are putting in place, these laws, they're meant to benefit employers just like they benefit employees. I know that anytime you get a really long, confusing, law passed and you as an employer feel like it's punitive or you're being punished, but that's not what's happening here. Workplace violence is a real problem and employers need and deserve guidance and how to keep their employees safe. I think that when you look at a very specific rule, and perhaps there will be specific rules from OSHA as well soon, it's easy to follow, generally speaking, right? Even if you don't like it, even if you don't agree with it, you can read it and implement it. So it says that you have to have, a certain kind of hard hat on in a certain kind of construction zone. So then you just make that your employees have a certain kind of hard hat on in a certain kind of construction zone versus looking at this general duty to provide a safe workplace where there's a lot of gray area in there and a lot of places for people to argue all sorts of things. There are things that are unreasonable, like inside of my law office. Do I need to provide everybody with a Kevlar vest? Probably not, right? Like that's probably not something that is reasonable or makes sense inside of this context. But having a specific rule that tells me exactly what kind of lock I need to have on the door or something like that, that protects me too as an employer, because now I know what is expected of me specifically instead of just generally. Like all new laws, there is always going to be confusion around what the law says you have to do and when you have to do it and how you have to do it. The interesting thing about the New York law, and really a lot of laws like this, is that it calls for additional rules to be set in place by a regulatory body. So some of what this act is going to require, we don't even know yet.
And how could VSO help with that and with what we know already and with what we don't yet know?
VSO law can help you in every possible way. We provide training and guidance to trainers who are going to be doing training themselves. We can help you get started on anticipating what a written workplace violence prevention program will look like. We can draft it for you. And certainly we'll pay attention and watch as this unfolds and make sure that the companies that we work with are able to stay in compliance every step of the way.